Okay, I would like to call the work session to order. This is a work session with design review and the planning commission of Wednesday, May 24th. And first we will take public comment. Is there any public comment?
We have to approve the agenda.
Oh, well, let's approve the agenda first.
Move that we approve the agenda.
Second?
All in favor?
Yes.
Yes. Oh, good. Okay, now we'll have public comment. Is there anyone that would like to make public comment before we start the meeting? Anybody on Zoom? Okay, thank you. So the purpose of the discussion tonight is to get land use training with the Planning Commission, Design Review, and City Council. So welcome to the planning commissioners that are here and Design Review that are here or online. And in talking with Carrie, our presenter, she said to make sure that if you have questions as we go, to go ahead and ask them. Just a reminder that we want to not speak specifically about any cases that might be pending. So in other words, no names, please. With situations that we will be facing, making decisions on. So if Carrie's ready, we're ready.
Thank you.
Welcome.
Thank you. A little bit of introduction. My name is Carrie Richter. I work with Bill Kvaisman at the law firm Bateman Seidel. Bill and I've worked together for about 20 something years. And he and I work with Cannon Beach. I primarily do land use matters for the municipalities that Bill and I represent. I know Bill is here more often, mostly because he has a beach house. If you really want to get down to it. But we represent many jurisdictions around the state, Oregon City, Nehalem, Wheeler, Cannon Beach. We have represented Astoria from time to time. We represent Island City out in the east and the metropolis of River Grove, Oregon, if you know where that is, just north of King City in the metro area. Consists of about 8 square blocks. Has a 1 stoplight. And they have no city hall. So they meet in the library and you get to sit in those little kindergarten chairs.
Oh, no.
And in the summer when the school's closed, they meet in the park. Let me tell you what it's like when you got all your papers out. And anyway, so that's a little bit about me. I am honored to be here and in front of you. I was telling some of you, I don't think I've been in person. It's Cannon Beach since before the pandemic. So I am honored to be here. My plan is to give you about an hour's worth of land use in a nutshell. The purpose of this presentation is to sort of give you a framework in which you're considering a framework in which you understand the applications that come before you. Land use applications come before all of you, and your job is to review them. And I want to talk a little bit about why things are the way they are, and so you sort of can understand the legal framework in which we have to review things. So that's my intent. I urge you to ask questions as we go along. Stump the chump. I'm here to answer any questions, or if I don't know the answer, I will go back and I will find it for you. So without further ado, let's get started. The Oregon Land Use Planning Framework consists of 3 baskets of laws or regulations that we have to follow. The first is the federal regulations. You're familiar with the Constitution, and the Constitution is what sets forth the takings clause. And so we have to do things like not require applicants to do more than the demands of their proposal because of the takings clause, for example. We know religious freedom. That's set forth in the Fifth Amendment. free exercise, and free speech. So those are guarantees in the Constitution, and that makes its way down into the regulations because we're subject to them. We have to comply with the federal laws, Fair Housing Act, ADA, Clean Water Act. All of those federal laws are implemented by the state and then implemented by the city. The state laws that we have to follow are set forth in the Oregon Revised Statutes. And those statutes set forth the land use procedures we have to follow. So those are not made up jurisdiction by jurisdiction. Those are set up in state law. We have to follow all of the special use protections. And there are many special use protections. The ones that people most often think about are farmland protections that don't allow particular types of development on farmland. But there are also special use protections that apply to cities, and that the one most often talked about these days is needed housing. And so there's a whole bundle of laws related to the provision of housing that constrain what local governments can and cannot do with respect to reviewing applications for housing. But there are a whole bunch of other special use rules, like there are rules about speedways in Morrow County. There are rules about where the urban growth boundary is for Metro. There are special rules about all kinds of different things, and those things then get those special use provisions and get implemented in our local code. So we don't have to go back and look at the laws when we review an application. The second component part of state regulations comes in the form of administrative rules. And the administrative rules consist of the statewide land use goals, 1 through 19. Those are adopted by the Land Conservation and Development Commission. That is an agency in Salem that is appointed by the governor, and they interpret rules and promulgate rules. And the 19 statewide planning goals are the principles that local governments have to plan to implement. And some of those rules, some of the statewide land use goals are very prescriptive, and some of them are more wide ranging, but those statewide land use goals are part of the administrative rules. Those goals are also implemented by additional rules. For example, goal 10 is the needed housing goal. And then there are a number of administrative rules that implement the provision of housing through those OARs. ODOT has administrative rules, Department of State Lands has administrative rules, and all of those make their way into the city's code and are implemented through city regulations. And on the land use side, from the city's perspective, we have, and I know you all know this, the comprehensive plan and map, right? Our long range planning document, how we're going to plan for growth and development over a 20-year horizon. And then we have the Cannon Beach Municipal Code. And that consists of, for land use purposes, chapter 16, which is subdivisions, and chapter 17, which is zoning. And then we have the zoning map. And so the zoning code and the zoning map are the development review, the short-term planning. You come with an application to build something, we look at the zoning map to see whether it's allowed. We look at the zoning code to see whether or not that use has the correct setbacks and the correct height. We don't go to the comprehensive plan because the comprehensive plan is implemented by the land use code. So the idea here is that you are building a tower essentially. And by the time you get to the top, you don't have to go back down to the bottom and check because you have complied all the way along. And that's why in many decisions, the comprehensive plan is not a criteria for review, or the statewide planning goals are not a criteria for review because we have already implemented those provisions in the code. And when you adopt new code, you're working on an update to your development code right now, I believe. When you adopt new code, you will send that to the Land Conservation Development Agency, which is known as the Department of Land Conservation and Development. I know it's like Tweedledee and Tweedledum. It's like, who knows what those names are. Anyway, they will essentially bless it And once you get blessed, we call that acknowledgement, the goals in the comprehensive plan fall out and just your code applies. So that's how acknowledgement works. And that is how the whole structure stays together. In the old days, we used to have something called periodic review, where every 10 years, local government had to submit their code to show that they were still in compliance. DLCD ran out of money for periodic review, I don't know, 15 years ago, 20 years ago. And so there hasn't been periodic review. And so that's a big stink for a lot of land use lawyers, because there's no real check to see if the tower is still perfectly aligned. And it's one of those things that we'd like to see come back. So it all started with Senate Bill 100, and you are lucky. This month marks the 50th year anniversary of the adoption of Senate Bill 100. So I would, I wouldn't be fair to my fellow land use advocates if I didn't give you a little bit of Tom McCall's favorite speech, famous Senate Bill 100 speech. And, there's a lot of people writing about Senate Bill 100 right now because it is the 50-year anniversary. And so a lot of things are coming up that I didn't know. I didn't know that Senate Bill 100 almost didn't pass, and it wouldn't have passed a session later, and it wouldn't have passed a session before. It came about in 1973 because the bottle bill was big, because President Nixon had just adopted NEPA. And so the environmental movement was really moving along. And so, when Tom McCall says Oregon is an inspiration to everyone, even those who do not come here to live. You and I can't say that we love Oregon more than anyone else, but we love the state as much as those who say they love it the most. Our thoughts today are in the deliberations to come will spring forward from our determination to keep Oregon lovable and livable. The gravest threat to the environment and the quality of life lies in the unfettered spoiling of the land. Sagebrush subdivisions, coastal condominium without vision threatens to mock Oregon's status as the environmental model for the nation of Oregon, if model for the nation. So, this was, momentous. And Oregon was one of the very first states to adopt a statewide land use program where every city had to adopt a comprehensive plan. And every comprehensive plan had to implement the statewide land use goals. There are about a third of the states to this day that don't have a statewide land use program, and they don't require adoption of a comprehensive plan. And so it is sort of ad hoc how decisions are made, and things like, the big challenge to the adoption of a decision in many jurisdictions is just, it's arbitrary and capricious, right? And what does that mean? It just doesn't have a sound foundation. Well, when you don't have a comprehensive plan and you don't have statewide land use goals that you're building on, you're going to get that kind of arbitrary decision-making outcome. And so that's what, that's why I feel, lucky to practice land use here, because we do have a statewide system. I'm licensed in Washington and land use in Washington. They don't have a standardized procedures. So in Washington, decisions could happen in 3 months. They could happen in 2 weeks. They don't have a 120-day rule. They don't have a land use board of appeals. So you go to circuit court. It's just much less structured. And so anyway, so that makes Oregon's land use system unique. I mentioned the statewide planning goals. You probably know what they are. Goal 1 is citizen involvement. And that has been the cornerstone of Oregon's land use program. And it is the cornerstone of all of the procedures that I'm going to talk about today. Managing urban growth, Goal 14, economic development, Goal 9, housing, Goal 10, transportation, Goal 12, and natural resources, Goal 5, and coastal resources, Goals 18 and 19. So all of this gets implemented in the local regulations. Are you moving it when I'm pushing the button?
There was a message that
Okay.
I was gonna say, if you're moving away, give you a sign or something. Okay, so land use planning Cannon Beach is divided into two categories. The first category is long range planning, that is legislative decision making. That is when you are adopting new code. When you are when you update your development code, that will be a legislative decision, making policy. And that type of decision making affects large areas. So the council makes the final decision after a recommendation by the planning commission in legislative decision making. And legislative decision making is political, right? So you go out and you ask your citizens, your fellow citizens, what they think you ought to do. And you go to neighborhood meetings and you go and you hold hearings and you listen to your constituents and they say what you ought to do. And then you implement policy. That's legislative decision making. The other type of decision making is called quasi judicial or administrative decision making. And this is this is when you are sitting as a judge. You are reviewing a proposal against a series of criteria. So you are adjudicating an application. So you're not making policy, you're implementing policy. And it's the quasi judicial administrative decisions that require application of criteria and a formal procedure where you don't go out in your community and ask people what they think about, the McDonald's that's proposed, what do you think of the Walmart? You don't do that because you're sitting as a judge. Your purview is only the things that happen in this council chamber. So only the written record that comes to you during the proceedings is relevant to your consideration. And not things like ex parte contacts, the things you read in the newspaper that happen outside of the hearings room. Questions about that?
I'm not sure. I might have, but you should go on and I can't articulate it right now.
Okay,
So
all right, well, jump in.
I will.
Please.
Thank you. Problem.
Okay, so I want to talk about the types of development review categories in Cannon Beach. So here we're just talking about the quasi-judicial, right? Where we've got more formal procedures, we've got very specific review requirements that we have to follow. So the type 1 staff decision is the development review that comes in with a building permit. So you're going to build a house and you come to Robert with your building permit plans. Robert's going to review the plans and he's going to check the box that says you've met the set. He looks at the plans and he measures the setbacks and says, yep, you've got the 15-foot setbacks and the building's less than 30 feet tall. And the windows are however the windows are supposed to be, and the garage is where the garage is supposed to be, as set forth in the code. And so he checks the boxes to ensure compliance with the code. The criteria that Robert's reviewing are quantitative. They are 35 feet, 10 feet, 15 feet away from a riparian corridor. These are what we call clear and objective quantitative standards. And so there's no discretion in the decision-making that Robert is implementing. And as a result, there is no notice, but there is a right to appeal to the Planning Commission.
Oh, I have a question then.
Please.
Okay, so if you have a right to appeal to the planning commission, but there's no notice, how does that work? I mean, because how are you going to know that unless somebody tells you, oh, I saw that they're building at the corner of such and such and such and such, you have no way of knowing. And then you have to fill out a form. You come to City Hall and have a public records request to see the building plans. And that's the only way you can figure out what's going on in your neighborhood.
Right. In most jurisdictions I represent, there is no right to appeal a building permit because of that reason. Because if Robert is only applying 30 feet, 35 feet tall and 15 feet deep and the quantitative criteria, there shouldn't be any mistake, right? There shouldn't be any, there's no discretion in Robert's evaluation. So there is no need for a right to appeal. The code does provide a right to appeal. I suspect it does because the assumption is that only the applicant would appeal, not neighbors.
But some jurisdictions put all of that online. They put, when you submit a planning permit, ask for a planning permit, everything shows up online on a public access platform called Excella. And you can actually see the design of the house. You can see everything that's there for type 1 and type 2. And it just seems to me that makes this meaningful,
That would be a way. Oftentimes, local governments give neighborhoods notice of building permit applications, just so that they know, so that there's transparent communication. But this could change. I mean, you could change this if you would like to. How the type 1 review happens, if you wanted to. The challenge is you don't want to make it so onerous for a person wanting to just build a house, right? I mean, so you've got to keep the other side of that is efficiency.
Yeah. That's true. And then you also have to have complete trust that when someone says they're building a 28-foot house, that it's not actually 30. I mean, you can't go out there and put up a step ladder and measure it yourself. So, when houses are built that are too tall.
Right. Well, the city has enforcement for situations where somebody builds something that was never. So that's another arm that could take care of that concern. So that's the type 1 review. So that's the over-the-counter permit, building permit. Type 2 staff decisions are home occupations and grading permits. In these cases, there's limited discretion and the initial decision is by the planning department, but notice is given to neighbors and there's a right to appeal to the planning commission. The type 3 staff decision is fairly similar to type 2. Another limited discretion decision. In this type, notice is given to neighbors with 20 days, with giving the neighbors 20 days to comment, and then the decision is made by the planning director, and the people who commented can appeal.
So I had a question. So what triggers the change from type 2 to type 3?
The code, go ahead, Rick.
I can speak to the application type that we get, and this is the only type 3 application type that I've ever seen. That is placing a shed over 120 square feet in a backyard. That is the only application that we have that is a type 3 permit.
All of the other.
Do that again?
The placement of a shed over 120 square feet or over 6 feet in height in your backyard.
What's the rule in that?
We basically, it's similar to a type 2, but we go through a public notice period. That's the difference.
Right, but what's the decision of the planning director?
The decision of the planning director is generally to approve unless we get some kind of negative
So
comment.
you're saying there's no code provision that reads upon this particular question, and that's,
It basically, like I said, it's like a type 2 with a comment period.
yeah. Well, the type 2 said limited discretion, so is that home occupation and grading permits?
Basically,
Thank you. Just wondered.
Can I come back to type 1 and Lisa's questioning? The type 1 staff decision, would be appealable to planning commission or council by someone who is an opponent of a project,
Yes,
if they know about it.
if they know about it.
Or to your point, that it may be the applicant because they're denied, correct?
Right. I think
That's an ob-
I think the intent was that it would be the applicant who would appeal because they were denied or their plan was revised in some way and they think that that's inconsistent with the code. I think that was what the drafters perceived that appeal would be. But I think it has been used by neighbors. And that is why Councilor Kerr has a comment.
But if we wanted the public to reasonably have a chance to make an appeal, we would only get that starting at type 2. Because you would have published, at least to the neighbors, the decision.
Correct.
And do we know what distance we're talking about for notice? Is it 100 feet or is it 250?
100 feet,
100,
type 2.
not very much.
So some jurisdictions merge these type 2, the way Cannon Beach has the type 2 and the type 3 together as what they call type 2. And under that entire umbrella, it is notice to neighbors with a comment period. So then neighbors get to comment and inform the planning director's decision, which is a more open avenue. And then if nobody comments, then you know you're in the clear, right? If you're an applicant, you know that you're, at least you have to get approval from the city, but at least you know your neighbors don't have concerns. Whereas in the way Cannon Beach does it with the type 2 for home occupations and grading permits, an applicant wouldn't know until an appeal happens, right? And so they wouldn't have much of an opportunity to know what the issues are. State law provides the structure for what Cannon Beach calls type 3, that notice and comment period piece. And so that is typically what we see as the type 2 decision. It seems like such an odd thing that you've got sheds as the only type 3 decision. But anyway.
So, and in type 2, you don't, I mean, it's already a done deal by the time because the decision is made. So,
Well, the neighbors have 14 days to appeal after the decision, right?
Yes, but they
So
wouldn't know.
they would be noticed of the decision, and then they have 14 days to decide if they did or didn't like that decision after the fact, right?
what if action had been taken before the 14-day period, or is that prohibited? You can't take action on your permit for 14 days.
I think you can't take action on your permit for 14 days to see if there's an appeal.
You cannot. Okay.
Well, I think we've seen that happen, though.
Yes, we have. That's why it seems to me, I don't know, this doesn't feel good to me.
Is there anything that prevents the city of Cannon Beach from having a transparency with type 1? Like you had mentioned, that website that would show it. There's nothing preventing us from implementing that, correct?
No.
So I can speak to this a little bit as well. So we do use the e-permitting system. Until recently, we've had issues with having documents that we upload visible to the public. We've figured out how to address that particular issue, and we're planning on uploading documents in such a way that they will be visible going forward.
So, so if someone wanted to, let's say I would go on once a week and look at all the type 1 and type 2 permits that have come through, I could see them.
May not see all the plans. I don't know if we're going to be scanning and uploading that because of time constraints. We'll see how that goes. But as far as other documents, decision documents, geotechnical reports, arborist reports, things like that, yes, you would be able to see
Oh,
those.
that's great.
I tried using that e-permitting yesterday to see what permit was being used for something. And I could not get into it. It is impossible to understand what it is you need to get. I mean, I had the address there, but I couldn't get anything. And I tried several times to get into it. So either we need it.
I can talk to you about it. It's a state provided system. It's provided by the Oregon State Building Codes, and I will agree it is not intuitive.
It's just, I couldn't, unless I knew what the application number was to put into it, I don't think I, to this day, would still be able to get in. I mean, I tried several times. I don't know if you need to have instructions right there. And in fact, I did look at the state instructions to see what else I could do, and I couldn't figure it out.
Is that on Excella, Nancy?
Huh?
Is that Excella?
No, I don't think so.
Okay,
It was ours,
Public side is called e-permitting.
yeah.
okay, because Excella, you just put in the record number of the area and everything comes up. I mean, it's the easiest thing to use. I'm not that good, as you know, Robert, on the computer, and I can do it. So,
Okay, moving beyond decisions where the planning director makes the initial decision. Now let's talk about the bread and butter of what the planning commission and design review board hears on a day-to-day basis. And these are the planning commission and design review board decisions. And these are conditional uses, variances, setback reductions, plan development, land divisions, and design review decisions. And these are discretionary reviews, and your job is to evaluate to determine whether or not the application satisfies the criteria. And the procedures that go along with it are notice, public hearing by the planning commission or design review board, and appeal rights to the city council. So you all are familiar with it. This is the process that you all use all the time. And then the final type that I want to talk quickly about are zoning code, map amendments, final concept PUD decisions. And these are sort of straddling the line between quasi judicial and legislative, in that here you are adjusting the map itself. You're adjusting the map for a particular applicant who doesn't want to do commercial but wants to do industrial, or doesn't want to do single family residential but wants to do multifamily. And so these types of decisions include notice, public hearing by the planning commission, and the planning commission then makes a recommendation to the city council. So the city council sees these automatically, regardless of how the planning commission does. Where the other ones you would take an appeal. Notice of appeal. So let's talk about the procedure, and the procedures are all about providing transparency, predictability, and a level playing field. So it starts with a pre-application meeting with city staff, where the applicant presents, conceptually what they're proposing, and staff gives them their thoughts. Then the application is filed and deemed complete. Oh, thank you. The application is filed and deemed complete, and an application gets filed, and what happens is that city staff reviews the application to see if it includes all the things that the code says it must include. But staff is not reviewing the application to see if it complies with the criteria. It's an administrative check the box. The code says you need a transportation study, and the applicant has included a transportation study. The merits of that transportation study are irrelevant at the completeness review time. So, and the reason why completeness review is important is because that starts the clock for when the city has to make a decision. Under state law, the city has 120 days to make a decision, and that is the final decision. That includes all the appeals. So if if you increase the appeal rights and you increase the time, you potentially put the city in a bind, because it has to take final action within 120 days. And if the city does not take action within 120 days, state law says that the applicant has a right to go to circuit court through a proceeding called a mandamus, where they ask a judge to order the city to approve the application. And the statute provides for an applicant's recovery of attorney fees if the city loses. So that is the disincentive to the local government to messing around and not moving applications through and not making decisions within 120 days. And 120 days goes lightning fast when you have to give notice before the planning commission or the DRB, and then you have to give notice before the city council, and you have to have continuances, and the time flies. So anyway,
So the 120-day time frame is one of the stressors for me anyway, right? I mean, I'm well aware of the things that have to be done, but it feels like what it's forcing us to do is if we can't get the answers we want, then are we better off to deny the application? I mean, because it's kind of forcing you in that position. You don't want to run out of time. And that doesn't feel right to me. Maybe I'm just making a statement of personal preference. You know, I would like to give the applicant more time to convince me or us, and I don't feel like I have that opportunity. Is that right?
The applicant the applicant is the holder of the timeline. So the applicant can agree to extend the 120-day clock. And so if you have an applicant who expresses an interest in understanding your concerns and potentially amending their application, the suggestion might be, will you be willing to extend the 120-day clock by 30 days or 60 days so that you can come back to us with a modified application? I mean, it's just that when you're faced with an applicant who wants to make a change, that change needs to come with an extension of the clock always, because we just never are going to have enough. You never have enough time.
Yeah. Okay.
Okay, so then city staff mails and posts notice of the hearing. And the statute provides what the notice has to include. State law provides 197797, specifies what the notice has to include. And it includes things like a list of the applicable criteria. It includes the address of the property. It includes the owner, and it includes the date of the hearing and where the hearing will be held. So we can always provide more notice, but we can't provide less than the state law requires. State law says that we have to have staff reports available to the public 7 days in advance of a hearing. And I think we post those online, right?
Correct.
And then at the hearing, you all begin all of the land use public hearings with that oh so entertaining series of quasi judicial disclosures that, one of the planning director in Oregon City always thought we ought to make a airline safety video out of the quasi judicial disclosures, and now those airline safety videos, they made them so clever, right? And so you have to raise all of your issues, or if you fail to raise your issues, something terrible happens to you, and then we have something terrible happening in the video. It could be so much more interesting. I think we all agree that is the most boring part of any land use hearing, is that stupid script. But unfortunately, that script is specified in state law. So we have to say the words we have to say. We have to tell people that they have to raise all of their issues, because the Land Use Board of Appeals, which is the court where land use cases are heard after the city council, is limited to the record that was created before the city council. So people have to raise their issues in order to preserve them for the Land Use Board of Appeals. And your code also allows the city council to do what's called an on the record review of an appeal, as opposed to de novo. On the record means you don't take new evidence. And so it's important that people who come to the DRB and the Planning Commission know that this may be their only chance to put in new facts. And the facts are critical if you're going to show that your application satisfies criteria, or you're going to show that it doesn't meet criteria. So raise it or waive it is one of the most important parts of those disclosures. The script also says that testimony has to be directed to the criteria. And I use this example a lot because I find it so infuriating. Church applicants, right? You get the pastor or the religious officiant who is so committed to the cause, and the church does such good work. And they provide childcare and they do all of these wonderful things. And that has nothing to do with the approval criteria, because whether or not the applicant is a good thing is never going to be one of the approval criteria, right? Because there's no standard in that, and there's no, that it's all up to somebody's judgment. So
We get that here also, where someone gets up and says, I've lived here for 35 years. My children went to the elementary school. I've been a great citizen, blah, blah, blah. And, that has nothing to do with any approval. It just drives me crazy. It happens every time.
So what I try to encourage the script reader to do is say, we cannot consider anything that doesn't relate to the approval criteria. And so urge people to understand these are the criteria, they're published in the staff report. We unfortunately cannot consider all of the sort of human elements of the application. So it's hard, and sometimes it's easier just to let people talk, but I think it's important that we're educating the public too. I mean, that's part of your role, is to educate the public about what land use requirements are, and they are the criteria only. There's another provision that says you have to raise constitutional issues, and that's really important for the lawyer part of this job, because if there's going to be a takings claim, in other words, the city has imposed a condition that an applicant thinks is inconsistent or not roughly proportional to the impacts of their development, they have to raise it. And that's really important, because if they didn't have to raise it, then they could be unhappy and they could just go sue the city in circuit court. And that gets really expensive really fast. And so the obligation is applicants have to raise constitutional concerns during the initial hearing.
Pardon.
Oh, excuse me. And then you have a right to an impartial tribunal, and we'll talk a little bit about that. At the initial hearing, the initial evidentiary hearing, any person can request a continuance and they get it. The second evidentiary hearing, people can request a continuance, but they don't get it. Except for if the decision maker wants to give it to them, or if new evidence has been presented at the second hearing that people say they would like an opportunity to respond to. So if I come to the second hearing with a new transportation study, and I haven't given it to staff, and Robert hasn't given it to you, and you all haven't seen it, and I bring it and I say, here's my new transportation study, and say I bring my transportation engineer, and he tells you about all that's in the report. And somebody stands up and says, I haven't had a chance to review the report, and this is new evidence, I'm entitled to an opportunity to respond. That's the only time folks are entitled to a second continuance. And it can take the form of a continuance. In other words, a hearing at the next hearing that staff is able to calendar, or it can take the form of what we call an open record period, where we allow the applicant 7 days, or we allow the person who wants the record to be open, we allow everyone first 7 days to respond in writing. Second 7 days is for all the people to respond to what they got in the first 7 days. Okay. And that deciding whether it's in response or not can be really difficult. So usually we're pretty flexible about that, honestly, because it's sometimes hard to tell whether something's in response or not. But that is what the law says about that. We call it a 7-7, and then the final 7 days is for the applicant to submit final written argument.
What about the clock?
Doesn't matter.
The 120-day clock,
Keeps on ticking.
it keeps on ticking.
Yes.
So couldn't somebody kind of subvert the process that way?
They could. And that's why we have to move through applications in a timely way because, well, so at the initial evidentiary hearing, you get a continuance out of the gate, right? And so you can either have it be a continued hearing where you resume the hearing where you left off at the next date, or you can do that 777 thing. The problem with the 777 thing is that takes 21 days. Oftentimes you can have a continued hearing faster than 21 days, right? So you have to decide what your hearing schedule is. If you only meet every 30 days, then 21 days would be faster. And then after the applicant submits final written argument, you resume your meeting and you just have deliberation because the record closes. There's no more testimony. It has happened all in writing. You resume for deliberation and a decision. So that 777 thing can be faster. But sometimes local governments don't like it as much because it's harder for the public to understand. I think people understand we're gonna have a continuous, we're gonna just come back and testify some more. But those are the two options under state law. So after we have the continuances and we have heard all the testimony from proponents and opponents, the applicant gets the last word. The applicant always goes last because they bear the burden of proof. They're the ones that have to put forward the evidence that shows the criteria are satisfied. So in the hearing script, the applicant always gets an opportunity to rebuttal. And that's why that final 7 days of time for final written argument, that stands in for that rebuttal that otherwise would happen in a public meeting. I mentioned the right to appeal to city council. This can be de novo or on the record to be determined by city council. All right, so I've talked a little bit about all of these. I'm gonna move a little more quickly here. Everybody has a role to play in what is often called type 3, but you all don't call it type 3 because you have a type 3 for sheds. So I shouldn't have written type 3 here. For your design review and planning commission decisions, the conditional uses, the variance, the meat and potatoes of what you all do. Everybody has a job to do. The applicant's job is to present evidence and arguments to show that the criteria are satisfied. They have submitted an application, they have evidence, and that is the role they play. Planning and legal staff, our job is to administer the process, issue staff reports and notices, and advise and assist you all in making a decision. And so our job is to know the laws, the comprehensive plan and the local codes and to help and be of aid to you in making a decision. Our land use planners have to comply with the APA code of ethics. And then of course, lawyers have to comply with the rules of discipline. So that's the planning legal staff's role. Planning legal staff don't advocate for an outcome. Their job is to call balls and strikes. Neighborhood groups and others and participants in the process are entitled to notice and an opportunity to participate consistent with the adopted procedures. And their job is to raise concerns with respect to the application materials that were provided. And, based on their evidence that they have to offer to you. And then as the decision maker, your job is to interpret and apply the plans and regulations. Educate the public about the land use requirements and provide a public forum for for land use cases to be heard. Do homework, that's the bummer part about being on the planning commission, right? And the city council, when you get appeals, right? It's just a lot of paperwork. And it's a lot to remember. And so, I really urge all of my decision makers to ask lots of questions. You have these applicants here, you have opponents here who have studied this. And so ask for greater clarification if there's something you don't understand. Be courageous and don't avoid hard decisions. I think all land use cases are often very hard, and it's hard to disappoint one side or the other side, and it's a lot of pressure. And I have the utmost respect for all of you who do this job, because it is a difficult one, and it takes a lot of hard, you have to make a lot of hard decisions.
Excuse me, I just have one question about under the planning legal staff.
Yeah.
You said that it's to advise, call balls and strikes, but our planning staff makes a recommendation all the time in the, when they give you the criteria and the facts, and then they say, planning recommends adopting this or turning it down. So how does that work? Because I've always had a real problem with that, because it seemed to me that it was influencing the planning commission where it shouldn't be by saying what they think, what their opinion is. And I thought that, at least according to what you just said, that's not the role.
Well, when I say call balls and strikes, I think that the role of the staff report is to identify the criteria and summarize for the decision maker what the evidence is. The evidence says, the evidence is that whatever the fact is. And if the staff believes that that is adequate to satisfy the criteria, then that's what they say. You may disagree. You may find that the criteria does not mean what staff thinks it does, or that the evidence is not substantial with respect to that standard.
But you're asking lay people in that situation to overstep a professional planner. And I think that puts the planning commission in kind of a tight bind, because they're sort of forced to say, well, I don't agree with the planning director who has all this education and, degrees in planning. I've just never understood that. And I understand what you're saying, but I think the reason why staff makes a recommendation is to help lay people, to offer some expertise in planning and in law, and to tell the planning commission the way the planning commission has considered these applications in the past or has interpreted criteria in the past, and to do that consistently. And I think I think that that's why that recommendation is valuable.
So it's optional, though, it sounds like. Is that what you're saying? It doesn't have to be there.
It doesn't have to be there. It would be, I think it would make, planning commission's job more difficult, because they wouldn't have the benefit of the analysis that was offered by staff. The staff report could say, the criteria is what the criteria is, and the criteria is compatibility with the neighborhood. And the applicant has put forth this evidence, and the neighbors have put forth this evidence, and just left it at that.
because isn't the decision maker supposed to evaluate evidence and then come to a conclusion? And if a judge in a case was giving his opinion ahead of time, I don't know, I do have.
I think it has to do with predictability and expediency. If you don't have a staff recommendation, you're going to have planning commissioners who are going to struggle more, I believe, because they won't know how to approach it.
I think we have a problem figuring out how to approach it when we get the recommendation without being offensive. And I'm sorry to say that. And I apologize to Robert after every meeting. So it's not a clear benefit to me. How do we go about changing something?
There have been times I've intentionally omitted having a recommendation.
I have a different opinion. We very much need a planning director in this community. And we need an experienced planning director. And I think as a community, we need to rely on their expertise. And if they were not to be able to give that, I don't believe they would be able with a straight face to be doing their job correctly as they've been trained to do. And that's my opinion and that's my viewpoint of it. I've been on the planning commission for over 8 years and a city councilor for 6 years. And I think it's of a benefit. If others of you don't feel that way, I can understand, but I just felt I needed to add it.
Well, it's a fair assessment. But what she mentioned is if they just present the evidence for and against and the criteria, that lets us as judge, like attorneys, as judge, decide. As opposed to wondering, how do I ask this without seeming to contradict somebody whose opinion I respect? And it's gotten difficult, and you've seen it in here.
Oh, yeah. I believe there's an adequate and respectful way to express a different opinion.
Not in the pressures. I mean, this is all great training and I've learned a lot, but we're not seeing appeals come at us this way. There are no clear cut yeses and nos. There's a lot of room for arguing over what the facts are and what the regulations are. And the last thing we need to do is get in an argument with staff in front of the public over who's right. That is the worst case, because then, it doesn't matter who's right or wrong. We've just established a record that our professional staff disagrees with our out of control planning commissioners. And oh my God, this has to go to the council.
Yeah, it seems to put the planning commission in an awkward spot. It's difficult as a planning commissioner to go against your planning director's recommendation, even if you really think that, that's what the evidence shows. Not everybody has that kind of, chutzpah to just say, well, I don't agree with that, or even say it nicely. I don't know. I just have
There's another thing too. I mean, it gets really bad when it's our attorney that starts arguing with us in meetings. And that, that basically just pretty much closes the case, doesn't it? I mean, it just takes the decision out of our hands. So the recommendations are, and maybe it's changed a little bit, and I think it has with Robert, were actually positions that staff was invested in. And we were getting in arguments with staff. And that's not right.
But maybe that's about a dynamic that we have, not about the process.
I'm not sure.
I mean, I feel that we have had some really excellent meetings with Robert.
I do too.
And I feel that when I receive a recommendation, I understand it's a recommendation, and I don't feel that I have to be personally antagonistic to someone if I say, thank you for the recommendation, and so I just feel that maybe we need to take this conversation to a different space. This isn't necessarily about a problem with our process, but maybe needs to be addressed in terms of how we're relating as planning commission and staff.
I agree. I mean, a little etiquette training would be great. My parents always tried to get me in it, and I wouldn't go.
Clearly it failed right now. Sorry, Mike, it's only because we're good friends.
More than once. No, and I agree with you and Robert, but can you see a problem when we're in a meeting and all of a sudden we're having a discussion with an attorney over our city attorney?
I think I feel a little differently about those conversations than you do, because I think that, as you know, I'm more likely to listen to what the attorney says and say, okay, I understand that point of view. So I'm probably not the person to have that conversation with you.
I gotta tell you, my experience at Intel was my position of attorney didn't mean jack shit. But anyway, just a thought.
Yeah, it is advice that we're getting. It doesn't mean we need to follow advice. So if you feel strongly about it, then you bring it up.
Mhm.
Well, that's the way I look at it. When I see the information that's presented in the packet, I see the staff report and it has advice for approval or disapproval or whatever the advice that's in there. I use that as a guideline to then go search through the evidence myself and see, okay, do I agree with this assessment of the advice? Do I agree with this assessment? And just work one step at a time, which may cause me to jump back and forth through the packet, but it gives me a direction to look through in terms of what's been submitted as the application. So I see a real benefit to it being there as in an advice position or category.
You know, can you guys hear me okay?
Who's me? Oh,
Yes, quite.
This is Clay, sorry. I actually, I've been thinking about this a lot, and I think there's good points all around, but one thing that occurs to me is I think having that disagreement with staff or with our council is actually probably a pretty good thing for the public to see. They need to know that we're thinking about it, that we don't always agree, that sometimes we're good pals and other times we're kind of duking it out. But at the end of the meeting, we're respectful and we have a lot of respect for the person, doing their job every day. It doesn't mean we agree with them. And I think that's important for the public to see. What we've talked about, and I think it's critically important in the time we live in, is to do it with respect. And if we can do that, if Robert makes an opinion and we don't agree with it, I think we've done a pretty good job of pushing back, and that's important for the public. So just my O2 for that particular line of things. I'm done.
Thank you.
Yeah.
The other thing I think that's important about this that I just want to mention quickly is this disagreement. The way I'm laying this out, I'm laying it out like it is really black and white. Like this is so obvious, right? It's never that way. It's messy, right? Muddy, and it doesn't come out that way. And part of the reason why I think it ends up being muddy is because the code is not as clear and directed as it should be. Yeah. And I know you all are working on a code update, and I can read code right now and I can say, this is going to be the perfect code. And then tomorrow it's going to not be the perfect code because some event will happen that we didn't predict. Something we didn't foresee. And so, codes have to be updated and you have to be willing to make the criteria be what you want to be evaluating. And, your job is hard or it's muddy because the criteria are not as clear and don't achieve the outcome that you want. They don't further the policy that you want to see. And so that is not the fault of Robert. That's the fault of the code.
Yeah.
Okay. Right to an impartial tribunal. You already know this. I'm sure, part of the entertaining disclosures hammered this into you. I said the decisions have to be based on the testimony and evidence that is part of the record. You have an obligation to disclose what we call ex parte contacts. Those are conversations or articles that you read outside the record. So you read an editorial, you see a blog post, you run into somebody at the grocery store and they say, boy, that Walmart is a terrible idea. And what do you say? I agree with you. It's a terrible idea. No, that's not what you say. What you say is, we're going to have a hearing on it next week. You should come and voice your opinion. Come. Please. I want to hear all about it at the hearing. And then what you do is you go home and you write an email to Robert, or you write it down on a piece of paper, your staff report, that on this date, a citizen came up to me in the grocery store and wanted to tell me about the Walmart. And then when you come to the hearing, you have a note, or you have already told Robert, and Robert will remind you that you have an ex parte contact to disclose. So at the beginning of the hearing, we ask for ex parte contacts, and that's your opportunity to say, I ran into a citizen at the grocery store. They wanted to tell me about Walmart. I told them to come to the hearing. We didn't discuss the merits of the case. And if you disclose your ex parte contacts, it cures any procedural problem that could come from that ex parte contact. If you read an editorial in the newspaper, you read a blog post, you send that article to Robert and we'll put it in the record. Because again, if we get it in the record, then we cure any potential procedural concern. So it's really important that you document these things when they happen and we get them in the record. Site visits. You are welcome to do a site visit in advance of a matter. Certainly, you're welcome to walk around and view the intersections at issue for yourself, the trees at issue for yourself. But you need to disclose that you did a site visit and what you took away from that. I took away that that tree was much larger than it looks in the plans. I took away that the traffic was much worse than I thought, than the traffic study seemed to reflect. You have to, if there are facts that you get from a site visit that are relevant to you in making a decision, you have to get them into the record so that people have an opportunity to comment about them. That's how we keep the purity of the record. And so if you are a trained geologist and you read a grading study or a natural or a riparian study, and you happen to know that a certain feature is a certain way or a certain soil is subject to slippage, or you happen to know that because of your business or because of your training, you have to disclose that too. Because the worst thing that can happen is you're in deliberations, the record's closed, and you say, well, you know, I am a geologist and I know that that geologic study isn't reliable because that soil is actually not this type of soil, it's another type of soil, and this will never work. Well, nobody knew about any of those facts that you have just put into the record during the deliberation after the record is closed to other parties. So all of this information that is you intend to use as part of your decision-making needs to be disclosed before parties have an opportunity to testify so that they can have an opportunity to put forth facts that may be different. Decision makers have to be free of actual bias. Actual bias is a predisposition rendering it impossible to make a decision based on the evidence and argument presented. Everybody has biases. I mean, there are certain kinds of things, certain kinds of people that you just cannot make a decision based on the criteria because of who they are, what they represent, what they're proposing. And there is nothing wrong with declaring that you have a bias and not participating. So if you have a bias that makes it so that you cannot make a decision based on the criteria and the facts that are presented, you have bias and you need to step down from participating. And you know, everybody has, you know, Walmart, you know, that was always there's a zillion bias cases about Walmart because nobody's on the fence about Walmart, right? So, you know, when you look at the Luba cases about bias, they're all Walmart cases. So, what you need to know about bias though, is that the bar is really high. The bar is really high. So, because the law assumes that you all live in the community. You all are part of a community. So if liquid natural gas is coming to your community, everybody's got a position on it, right? You'd have to be living under a rock, right? So the law assumes that you are out in the community, that you are listening to your constituents who have concerns, but that when you realize when you come to evaluate an application for a particular proposal, you can set that aside, whatever your personal feelings are and make a decision based strictly on the criteria. And if you can't, you need to step down. Decision makers can't have an actual conflict of interest. That means a pecuniary interest in an outcome. So you and your relatives can't stand to gain, if your son mows the grass at the golf course and the golf course comes with an application, you'd have to recuse yourself because you have a conflict of interest. Hard to imagine, but anyway, that's what the law says. So, moving on. Let's see, I've got more here about ex parte contacts. And I just explained all of this. You have to place on the record the substance of the contact. And you have to make a public announcement. And I've quoted the law here. Communication between city staff and the planning commission or governing body shall not be considered an ex parte contact. So just so you know that. And in fact, I encourage all of my decision makers to have conversations with staff in advance of a hearing. And the reason why is because we can help you answer questions. We can help you understand the evidence. I mean, that's our job. So if there's something that we can help you better understand or get you something additional or anything, that's what we're here for. And it's, I think, always better to have given you the information you need in advance so that you can be really productive during the hearing when people come to testify, rather than having to scramble at the hearing. So that's my advice about that.
Carrie,
Yes.
we have a hand.
Oh, we have a hand.
Hi, Clay Newton again, I'm Planning Commission. I wanted to jump back to your point about site visit. When we all declare whether we've made a site visit or not, and then the next step is to say if we have anything, any concerns or new revelations from that site visit, is that based on our specific experience or specific expertise, or is that based on an opinion when we go out there? Like we go out to a site and I'm trying to think of an example that doesn't relate to anything we're working on. So, if I go to a site and I have an opinion about how something was handled, but it isn't based on a specific expertise, that's just an opinion. That opinion could be shaped by the evidence presented, after testimony. I guess part of the challenge for me is we're making the declaration about a site visit before we're hearing testimony, so that opinion may shift. So is the need to declare any sort of concern relative to a site visit around specific experience, or is that just, hey, I think they missed this based on my personal opinion of this UU's geology report? I'll stick with that. Based on my common sense reading of this geology report. Do I need to state that at the time, or can I wait for them to address it?
Well, your experience with a geology report isn't an ex parte contact because the geology report's in the record.
Yeah, no, sorry, I brought this up. I brought this up in the context as you were speaking about ex parte contact, but I've been sitting on it since you brought up the site visit section where we have to disclose if we have an opinion there.
So let's say you go to a site visit of a slope and you've looked at the geologic report, and the geologic report says, it talks about the stability of the slope, and you go out there and you look at it, and what occurs to you when you look at it is that it's steeper than you thought, or it doesn't, the amount of landscaping that will hold the hill is not what you think the geology report shows, or that there's a slump where the geology report doesn't show it. And so during your ex parte disclosures, you're going to say, I went out and made a site visit and I noticed right here in your report, there's a slump. I noticed right here in your report, there's a bunch of trees. I noticed that the slope is steep. It occurred to me that the slope is steeper than maybe I had previously thought. It's not so much that you have expertise in it, but you what occurs to you when you make a site visit is those are facts that you are taking in that are influencing your decision, and parties are entitled to an opportunity to rebut those facts. And you guys get testimony from people who say the traffic was much worse. It's much worse than the transportation engineer said it was, right? You get statements like that. You go to a site visit, you might see the same thing. So you need to put that traffic seemed, there was a ton of traffic. I was there during a school drop off and you say the cars only go back 5 cars, but I saw cars going back 10 cars. So, I mean, and we don't want to be argumentative. What I would encourage you to do is just make a list while you're at the site visit or when you get home of the things that seem relevant. What is going to influence you that you got out of it? I think oftentimes you go to a site and it looks like what you thought it looked like. It looks like when you drive by it every single day, I mean, so, it may well be nothing different. Nothing came from the site visit itself. Is that helpful?
It is, yeah. I think I still come up with, what I don't want to do is put, as chair, I don't want to ask, is there anything anyone would like to add about or are concerned about after their site visit? And then, later through the testimony, something, the light goes off and we're thinking about it differently, but we hadn't brought it up initially and maybe the record's closed. And now all of a sudden people can come back and say, well, you can't add that because you didn't voice it as a concern. I don't want to box us in that way to a process that sometimes is a lot more organic than just what I might come up with when I'm standing looking over a particular site.
I understand that. And yeah, I appreciate that the process, the hearing is often much more dynamic than I'm making it out to be. But I'm trying to aspire to some practice principles that have been helpful. I understand that there are going to be times that during the hearing, things are going to occur to you. And when things occur to you, then you ought to bring them up while the hearing's open to the extent you can.
Okay.
And,
all right.
And you're not saying that when we declare a site visit, that we should read off a list of all of our facts and observations at the point, but it can come up in discussion and that makes it part of the record.
Yes, it can come up in discussion while the record's open, but not during deliberation.
Okay.
Deliberation is where you all are talking about how you're going to interpret the criteria and how you feel the criteria is satisfied or not satisfied. That's where it gets really dangerous. And most of it is benign. Most of it is fine. But I have seen situations where somebody happens to be trained in some field and they come and in deliberation, they just, explain to the planning commission all the reasons why a particular expert's report is fallacious. And that it's just not, that's not, those are all new facts. And that prejudices the process. All right. So public meeting requirements, that the city has to comply with the open meeting and open public records requirements set by the state. And that a public meeting occurs when a majority or what we call a quorum is deliberating to a decision. So if you all get together for knit nights on a rainy February night and talk about, chocolate chip cookie recipes, no problem. But if the conversation devolves into matters before the planning commission or before the DRB, that's a public meeting. Public meetings, we have to have minutes and they have to be open to the public. So that can be a problem. So try not to talk about work at home, right? Try not to talk about business of the planning commission with a quorum of you. If 2 of you want to go to a site visit, that's okay, as long as that's not a quorum of your organization. So in this case, it would not be. So if 2 of you wanted to go do walk and do a site visit, as long as you disclose it, be fine. You have to be careful about conference calls or chain emails. So don't hit reply all, right? When you receive the packet from Robert, don't hit reply all, because that can create a public meeting. And if one counselor emails another counselor who emails another counselor who emails another counselor, even though they are separate emails, that can create a public meeting. And Lane County received a judgment against it for couple $100,000 when they decided to discuss letting a particular contract by serial. So don't do that. If you have a question, make sure you direct it to Robert. And if Robert wants to follow up with all of you, he will do that. But don't hit reply all. Some of you have city emails. I believe the council has councilors have city email addresses, but I believe the planning commission does not. And the DRB does not. Is that correct? So with respect to public records, almost any writing or other record relating to city business could be a public record. So keep city business separate from personal business. And for those of you who don't have your own email account or separate email accounts, I would make a folder and put everything in a folder. If the city receives a public records request for your records, we have to be able to access them, and we prefer not to have to go through your entire computer to have to locate the things that are related to city business and the things that are related to your child's Christmas list. Keep those separate to the best you can. I try to urge decision makers to avoid commenting on instant messages or chat rooms, because those are most often not captured by the public records law. So we wouldn't have access to hold them and provide them if we got a public records request. So try to avoid that. You know that your notes that you take during meetings could be public records. So you're working on your grocery list, those could be public records, and texting during meetings, those can be public records because you are conducting city business during these meetings. So be careful with your texting. There's a West Lynn case where a city councilor would take notes and she would doodle. And the now mayor of West Lynn filed a public records request for her notes. And they were, her thoughts, her sort of mental images of what was happening during. And the city of West Lynn fought hard to keep those notes from going public. And they did go public because she was acting as a public body. So,
where can we see them?
myself, but I just, it's a situation. You got the mayor suing one of the counselors for he's a law student.
Wow.
He decides to file a public records request as experience. They're in the course of the trial. They're in the course of the litigation, and he gets elected mayor. Like, that's awkward. So anyway, when in doubt about public records, public meetings, ask the city attorney, ask the city recorder. Again, we are here to help you sort this all out. So just ask. Okay, now we've come to the deliberation and decision part, and this is where things get muddy sometimes. And the question is whether the applicant has met its burden to show that the applicable standards are satisfied. And there are three parts to, there's lots of parts, but from a legal perspective, there are three tasks that a decision maker has to engage in. The first one is interpreting the applicable criteria. And that means giving meaning to ambiguous standards. And the way we do that is we look at the text of the criteria, the context, and any purpose and policy that may inform an ambiguous criteria. So your job first is to interpret discretionary criteria. So compatibility with the neighborhood. What does it mean to be compatible? Well, what does the neighborhood contain right now? Is it match that or does it not? How matching does it have to be? Right? Can it be a little different? Can it be a lot different? You know, that is where that's why you make the big money, right? So that's interpreting the criteria. The second job is providing adequate findings, and that means the explanation, how you explain the way you have interpreted the standard and how the evidence measures up to show that the criteria is satisfied. And that's one of the big benefits of a staff report, because the staff provides the sort of a suggestion of findings. If there wasn't a staff report, I'd come to a meeting, you know, having to write, Robert and I would have to write the findings at the meeting. Meetings would take a lot longer because the findings would have to be written on the fly. Whereas if we have the benefit of some staff findings, then we can change them, revise them, but we have something to start with, assuming that the council interprets the standards the same way.
Clay, do you have a question? Is your hands up? Clay?
Sorry, I had to unmute. No, I don't think my hand's up.
It is.
No, well, you can take it off. I think that was for my last question.
Okay, thank you.
Yep, thank you.
The third legal requirement for decisions is that they have to be based on substantial evidence. And that is a term of art that means whether a reasonable person would look at the evidence and find that it satisfies the standards. Well, a reasonable person standard is quite broad, right? It's quite broad. The bar is pretty low. So when you've got but it's your job to weigh the evidence. So you have evidence of that the criteria are satisfied and evidence that the criteria are not satisfied. You get to decide who to believe. But if you've got an expert and lay testimony, and you're going to believe lay testimony, you have to explain why that lay testimony is more credible in your view. Again, it all comes down to the explanation, the quality of the findings. If you can explain it, and then it is likely that LUVA will give deference to it as you have explained it. And so if your interpretations are consistent with the text of the code, purpose and policy, LUVA will affirm city council decisions that are not inconsistent with those purposes and policies. So you've got a wide lane. LUVA gives deference to city council's interpretations of its code, right? But you can't make up new code. And you can't interpret it in a way that is inconsistent with the purpose and policy or the plain language. So if we have a definition of a term in the code, you have to use the definition. You've got adequate findings, means an explanation of the evidence you found substantial and why that satisfies the criteria. LUVA is going to affirm those decisions, and then the city's done its job. The final thing you know about conditions of approval, and conditions of approval may be attached to ensure that all the applicable approval standards can be met. Conditions of approval are in most cases permissive. Local government doesn't have to attach conditions of approval if it doesn't want to, except for housing. That's part of the new laws with housing. If you can condition it, you have to try. You may not be able to condition it, but the new law is you have to condition it if you can.
Can you give an example of what you're saying?
of a housing
Yeah,
condition. A person comes with a triplex proposal and the code says that, you have to have it, it has to, and the structure has to be set back a certain distance. I mean, this is a super simple one, but, and the applicant has shown that the setback isn't met. If this was a Walmart, you could deny it because they haven't satisfied the setbacks. In the case of a housing application, you have to condition them to move the building back to meet the setback.
say that in a different way.
So if the building wouldn't meet the setback's 15 feet, let's say,
Right.
and I put forth a proposal that only shows 5 feet. You, as the decision maker, would have to approve the application with a condition that says, move your building back another 10 feet.
So you'd have to require it. You could require it, but you have to approve it.
As opposed to deny.
Yeah.
That's hard to do in the design review space where you don't see a proposal, right? And so if you don't see the proposal, let's say the city has transparency requirements and, a number of windows you have to have, and an applicant doesn't have those. Well, if you're going to approve it, say, you've got to increase the transparency, well, that will change the design of the building, right? And so you'd like to see that before you approve it. I'm a historic preservationist by training, and it's a real problem in historic preservation because you want to see what it's going to look like. And so oftentimes what I recommend is if you're moving towards, you're finding that that a criteria isn't satisfied, because it's not going to be as simple as the 15-foot setback I just gave you. You're finding that the criteria isn't satisfied, ask the applicant to come back with revised drawings so you can see it. And then impose the condition if you want to, but see it, because then everybody knows what they're getting into. The other thing you need to know about conditions of approval is that conditions of approval cannot kick the can down the road. In other words, the condition of approval can say, when you come back with your building permit, you shall provide a design that's compatible with the neighborhood. Right, that's what the criteria says, right? And that doesn't give an applicant clear and objective direction on how they are going to satisfy the correct condition. And there's a rule that says if you impose a discretionary condition and you don't provide notice and opportunity for comment like you would if you had applied the criteria if you applied the criterion originally, then that's a violation of state law. So in other words, if I approve a grading permit, say, and the condition says you will submit a geologic hazard study that shows that the slopes are stable. Well, what does it mean for the slopes to be stable? And isn't that the criteria now? And if Robert and I decide whether or not the slopes are stable, the public doesn't get an opportunity to come in and comment on that study. So if the condition needs to be something along the lines of the applicant shall build what is shown in the study. The applicant shall install high cables, or the applicant shall return to the city with X, Y, and Z. And you can have a condition that says you have to come back before the planning commission or the DRB or to fulfill the condition. So that solves the discretionary condition problem. Right? You can ask an applicant to come back through a type 2 or a type 3 review.
So, sorry, so one of my courses could be to, with a geologic study or whatever it is. Anyway, I could request the applicant to provide more data and ask for an extension
Mhm.
at the same time.
Mhm.
Or you could you could make a decision with a
Condition.
condition
Mhm.
that effectively does the same thing.
Yes. The condition would say, when you file your building permit, you're going to include a geologic hazard study that does X, Y, and Z, and we're going to review it as a type 3 decision.
And that won't run up against the 120 day.
Because you'll have made a final decision and you're going to start over when the person files the application. Again, I mean, but you're balancing efficiency here and with, you know, it seems to me that if there is a clear and objective condition that would work, that would be the best course. You know, because we're trying to help people build things or develop things or conserve things, because that's what our code specifies that you can do. Right? That's what we're trying to do. I mean, that's, we're trying to give clear and predictable advice.
So there's been a change in law. And you're telling us we can tell them to modify their package and bring it back to us. Or we can approve it with the condition they modify the package in accordance with objective standards and bring it back to us, as opposed to saying no.
Yes.
Or we can say no and give them the condition, the reasons why.
Yeah.
Either one. Okay, good. Thank you. Very good.
Okay, I promise I know, it's a lot. Sorry. I said 2 hours, didn't I? Well, I said 1 hour. Didn't I? I'm sorry. I get so excited. I know this is unexciting to anybody except for me, but okay, housing decision limitations. I know you all have talked about this. You know, this is a recent change in the law and it has been hard for everyone to get their head around, but when we're reviewing applications for housing, we have an obligation to apply only clear and objective standards. And what's happened in lots of jurisdictions is that they didn't change their codes immediately after the law changed. So we have all these residual codes out there that are not clear and objective, or we changed our housing code, but we didn't change our grading code, or we didn't change our PUD code. I mean, I just lost a case on Monday over a PUD code in Oregon City because the standards aren't clear and objective. So I mean, everybody's tripping up over this. It's a pain. And it's expensive to change your code and make it clear and objective. And, you know, clear and objective standards are hard to write. And, you know, developers may not really want them at the end of the day either. But it's not my job to judge. My job is to tell you what the law is, and the law is clear and objective. Clear and objective standards are things that are quantifiable. 5 feet. You know, roof pitch angles. Things that are not clear and objective is ground floor. Things that are not clear and objectives are things that are compatible. Things, criteria like compatible with your comprehensive plan was what got us caught up in Oregon City. So those things are not clear and objective. And if they are not clear and objective, they do not apply, which just cuts the legs out of a lot of our codes and criteria. This clear and objective obligation applies to subdivisions, partitions, manufactured home parks, geologic hazard stream corridor review when a house is proposed, and design review. So, I mean, it's pretty much a lot. And you have an obligation. The rule is you have to have a clear and objective track. If you have a clear and objective track, a developer can choose that track, or they can choose a discretionary track. If you don't have a discretionary track, I mean, if you don't have a clear and objective track, you can't have a discretionary track. And so that's how we get away with variances and the plan unit development codes. Those are discretionary because an applicant has the ability to not get that variance or not go with the plan unit development. So that's how we get away with that discretionary review as an alternate track.
And am I correct? I think I heard Bill say once that no can be a clear and objective standard. Is that true or not?
No,
So in other words, you could say there will be no building in this area,
yes,
but you may choose a discretionary track and apply for. So is that
yes, that is correct.
a correct understanding? Okay.
Yes, so the clear and objective track could be, you can't build here, you can't build at a certain height, absolutely. And that's, I think, what developers are finding is the problem with clear and objective tracks. And I don't know if you're following the legislature right now, but there's a bill that will allow variances to clear and objective standards because developers aren't too happy with their standards. House Bill 3141, I'm really opposed, but anyway. We have to apply not only clear and objective standards, but we have to apply clear and objective procedures too. And I'm not entirely clear on what a discretionary procedure is, but certainly the types that you all are hearing are discretionary procedures. We will see in the evolution of the courts whether or not those procedures have to change. Right now, we're okay, but I don't know. So I set forth in this slides some examples of non-discretionary and discretionary standards. As you know, the oceanfront setback determination scheme here in Cannon Beach was the subject of a clear and objective challenge, and the Court of Appeals said that that is a non-discretionary standard. Design review criteria, like the arrangement of all functions, uses, and improvements has been designed so as to reflect and harmonize with the natural characteristics and limitations of the site and adjacent sites. That's highly discretionary because what it takes to harmonize could be depend on opinion. Okay. I told you that quasi-judicial decisions have to be explained. You have to identify the approval criteria and list the facts. We talked about your personal experience. When you have conflicting evidence, you have to state why the evidence is more reliable and credible and entitled to greater weight. Conditions of approval, quickly, I talked about the limitations and conditions of approval a little bit, but the other one that's really important is the takings one, which is exactly where I started. Conditions of approval that obligate applicants to do something have to be directly connected to the development itself. And that is called the nexus between the condition, obligation, and the proposal. And the seminal case in this is in California, where the Beach Commission made an applicant provide a public trail through their land to the beach as a condition of getting a building permit for a house. And because the house had nothing to do with the public path, there was no nexus, and that violated the Queen's Clause of the Constitution. So that has to be a nexus, and there has to be roughly, there has to be rough proportionality. That means that the extent of the impacts have to be proportional to the extent of the obligation. And the seminal case of this is Dolan versus City of Tigard, where the A-boy was going to go in and the City of Tigard required them to build a trail, actually build a pedestrian bike trail. And the court said that the impacts from the A-boy would not need a full pedestrian bike trail. And so that was not roughly proportional. And when we see the rough proportionality obligation come up a lot is with respect to sidewalks, where the city requires sidewalks. And some applicants say, well, I'm not going to use the whole sidewalk. The courts have said is sidewalks in front of a residence, you do. But sidewalks away from the residence, you may not have to, depending on how many residents would be using the sidewalk. And the important part about this rough proportionality obligation is that the burden switches to the city in these cases to show that the obligation is roughly proportional, where the burden rests with the applicant all along. And then when it comes to drafting conditions, the burden rests with the city to show that it's roughly proportional. So this often comes up in road improvement obligations and sidewalks. Finally, I want to conclude with some recommendations for effective participation. And I've talked about all of these. Avoid ex parte contacts or be aware of evidence and be prepared to disclose evidence that you get from outside the hearing. Be attentive and prepared. It just helps the process so much more if you are ready with your questions and prepared to act. Helps the process, helps us make the 120-day deadline. Don't be afraid to ask questions of staff and the attorneys before the hearing, and ask questions of all the parties. But do it respectfully. And the way I've seen it be most respectful is to ask open-ended questions. Am I understanding you right when you say, did I hear you correctly when you said, I'm struggling to understand this. Just using a different tone can sometimes change the whole way the hearing can proceed. Use the criteria. Decisions have to be based on the criteria. If you don't agree with the criteria, that we need to work to change the criteria. We can't just not apply the criteria or apply the criteria differently. Don't be afraid to disagree. Sharing perspectives ensures that the decision is in the city's best interest. So with that, I will open the floor. It was always open, but please. You're not asleep. Get some snacks. No.
I just want to say that was a great presentation. It was fantastic. I don't know if you teach, but you should teach. You're really good.
Thank you. I am always available. Bill is always available. Robert's always available. Steve will be available.
I will be giving recommendations.
I did have a question back at the housing decision limitations.
Yes.
For the, what was it? So let me see if I reorganize my question, my thoughts. Were the conditions of approval for housing situations where you can't deny it, but you can put conditions of approval?
You have to try.
Okay, so if like you gave an example, you want to see whatever it is in the plans before, if you request that, and then the next meeting, for whatever reason, they weren't able to get plans put together or whatever, are you then stuck with the decision to then apply that condition of approval without seeing it? Or is the option to deny it because they didn't provide whatever it was?
It's a hard question.
An
It's a
option.
really hard question. And
Our hands aren't tied, though. It's it comes up to our discretion as.
it's a hard question because what the law says is you have to allow the applicant the opportunity to propose conditions. So the applicant says, condition me on moving the building back 15 feet. And you'd say, I'd like to, but I haven't seen it.
Mhm.
I'm worried that I'm not sure if we move it back this way, what will that do to the back of the house? Or what will that do over here? And ask them, what will that do over here? How are you going to meet your lot coverage requirements or your off-street parking requirements if you move the building here?
Mhm.
And ask them to answer that question. And if they can't answer the question, you say, I've got this criteria here that says you got to meet this lot coverage requirement.
Mhm.
And I can't see that you will satisfy that if you move the building here. Do you see what I'm saying?
Yeah.
So you're gonna solve one problem, but you're gonna create another one.
Mhm.
Right? And so you would deny potentially because you can't solve that other problem. Do you see what I'm saying?
Okay,
I mean,
all right.
it's.
I was just concerned, like when the way I was first interpreting what you were saying is that if you could request them to come back, but then your hands are then tied that you're approving with that condition without having seen it at that point.
Yeah, no. If you cannot determine that the criteria are satisfied with the condition, you cannot approve the application. I mean, that's where that's the legal answer to that question.
Okay.
Okay,
Well, I have a question about, sorry,
So go ahead.
about continuance. I think you said that a good reason for a continuance would be an applicant once would request an extension on that 120 days to provide some kind of rebuttal. Can you, what are other good reasons to do a continuance?
There's no other reason. No, the only legal reason that you have to grant a continuance is because new evidence came in at the hearing and someone wants an opportunity to respond. It doesn't have to be the applicant. It can be anybody. But if I am representing an applicant and I submit a traffic study to Robert 3 days in advance of the hearing and he posts it somewhere, or it is available somewhere, then that is not new evidence that comes at the hearing. I mean, I'm trying, you're supposed to have very few opportunities for continuance because continuance pushes us against the 120-day rule, right? So we want to be frugal with our continuances. And I think that what happens is that you have because you have to grant the initial continuance, people think that you'll continue granting them. And that we can't have it, right? And so I think when people ask for a continuance, they want to continue the conversation because they are concerned, but you have to have an end. And so the only time you have to grant a continuance is when you get new information at the hearing that people have not had an opportunity to respond to.
Thank you.
I do, I kind of piggyback on his question. If you meet only once a month, if you're a body that meets only once a month, and you think there needs to be a continuance, can you meet again that within that month and that say, as long as the
Special meeting.
and public notices requirement is met, you could meet a second time in that month in a special meeting to consider that application.
And oftentimes when we're up against the 120-day rule, we have to call special meetings in order for us to get through to meet the deadlines.
So you don't have to follow the 777. You could meet 2 weeks after.
Well, if you're going to do that 777 thing, you have to have 21 days in which to do it. But if you don't have that much time, you have a continuance to a subsequent hearing that can be less than 21 days away.
Right.
You call a special meeting. And so the important part about about the continued hearing date, you have to, at the hearing where you're going to grant the continuance, you have to say what that date will be. We call it, you have to say the date certain. We're going to meet, usually we meet on the first Wednesday, but we're going to meet next Wednesday. And it's going to meet at 7 o'clock and it's going to be here. And that's how it works.
So flesh that out a little bit more for me. So under what conditions would you be, so if you have your special meeting in 2 weeks and you set your day, you're not going to allow new evidence because you're not going to have enough time to do all the things that are required, right? So what could you do in 2 weeks? I'm not clear on what circumstance that would come up. It feels like we always are looking for more data. When we see a continuation. And I'm just not sure what would work with a 2 week.
Well, I
haven't seen it.
Supplemental transportation studies can be done. Where a traffic engineer goes out and looks at the records with respect to crashes, that could be done.
Right.
There's all kinds of things that can be produced in a short amount of time. It doesn't have to be what you think would be a sufficient amount of time. You're saying if the information you want will take a month to make? And so you think we need to give them a month because it will take that long to create it?
Well, I mean, no, I'm just thinking, okay, so I want a traffic study or I want additional data. Irregardless, that is new evidence, right? And so don't you run the trigger of you've got new data, then you've got to allow time for understanding and a rebuttal. And how does that add up to just 2 weeks? I guess is my question. It seems like you would always have.
You're giving me the example of you come with a new traffic study and then I come with a new traffic study, then you come with a new traffic study and we're in a circle, right? Is
Right.
that the example? So yes, that could happen. But when we give instructions for, we're going to continue the hearing for another 2 weeks. We are only going to hear rebuttal evidence regarding this issue in a traffic study.
Okay.
We're not going to hear about trees. We're not going to hear about design. We're not going to hear about, we're going to only hear about this issue. And so when you come at the continued hearing, you're going to hear from anybody who wants to talk about that issue.
Okay.
And then you're going to make a decision. I mean, that is how you avoid the hamster wheel. Your question about whether or not it gives people enough time to produce the evidence you want them to produce is a question that the law doesn't say you have to give people a reasonable amount of time. We have an obligation as a city to make a decision in 120 days. We have a schedule we have to keep. We have to give the city council time to hear an appeal, and we have to comply with the notice requirements that have to precede that. So we can't give you 60 days to produce a study. If you want 60 days to produce a study, you've got to extend the 120-day clock to allow for 60 days to produce a study. That kind of answer?
I think I understand what you're.
Ask my question one more way.
Let me see if I understood your question. So I think when we talked about the 777, it was important to provide enough time because there was not going to be a public
Yeah.
portion when you next met. It was going to be only deliberations. But if you're doing a special meeting, that implies that there is still going to be public comment. And that's when that gives people chance for rebuttal. So you don't have to give them that special 777.
Yeah, that's kind
It's
of.
going to happen at the meeting instead.
So as long as it's new data, it is new data, but as long as it's presented in a public forum, you don't have to allow a special amount of time for everybody to understand it. That was specific to the 7, and 7.
Yeah. Yeah.
Okay.
And it's important to remember that the record will be open for the whole time of the continuance too. So people can submit stuff in writing all the way coming up to that
Okay.
will be the second
All
hearing.
right. Thank you.
So planning commission made a decision,
Mhm.
and that decision was appealed. It was appealed to the council.
Mhm.
The council, based on this, would probably have a special meeting to address it. And the planning commission voice an opinion during that special meeting.
So that's a difficult, so they cannot voice, it depends on why they're there. If the planning commission has authorized them to come to the meeting and explain the planning commission's position, that's one thing. So they have to have a majority vote to send you to go and speak on behalf of the planning commission. Okay, that's the only time. If you're going to participate as a decision maker, you're kind of giving up your right to participate as an individual. If you want to testify about the merits of something, you need to recuse yourself, and then you're certainly free to testify before the planning commission, the DRB, or the city council about something. But you can't be the decision maker and then turn around and take off that hat and advocate for an outcome.
So in order for the planning commission to elect somebody to represent them to explain position in person to the city council, when does that happen? Does it have to happen during one of the planning commission meetings?
It does. It would.
Okay.
And I've only seen it happen once, and that was when there was not a lot of trust between the planning staff and the planning commission. And so they felt like the planning commission, that the planning staff wouldn't represent the decision of the planning commission very well. And so
But that's the only way that the planning commission could nominate somebody to explain their position.
the only way that anybody can testify on behalf of anybody is if the body authorizes them to do it.
In one of their meetings.
But the city council could receive the minutes of the meetings.
Oh, absolutely. You're gonna receive the videos, right? The videotapes. You're gonna receive all the written documentation that was received. And your job is to review those videos and watch the proceeding and be aware of what happened before. I mean, if that's what part of the packet, it's part of the record.
I'm not trying to imply that the council would not review everything appropriately. There's sometimes situations where it's easier to explain in person than it is to glean the information from the meeting notes and the videos without going into specifics. Thank you.
Hey, come on, come on.
Is there anyone online that would like to ask a question?
Okay, I had one more question.
Yeah.
Sorry to go back to this because it drives me crazy. It's the continuance issue. If the applicant asks for a continuance, does that always stop the 120-day clock?
No, the applicant has to affirmatively extend the 120-day clock. So and it has to be in writing too.
Oh, okay.
So what happens at the hearing is I say, I would like an additional 30 days. And you would say, will you extend the 120-day clock for that to accommodate that? And I would say, yes. And then it's up to Robert or me to follow up with that applicant with an email. And oftentimes I'll email them during the meeting. Send me an email confirming you've just extended the 120-day clock by 30 days. And then they come back and say, yes. So, because it's really important that we know exactly what the day is. It's really important.
Okay, but they're the only party who
They're
can,
the only party that can
ask to extend that 120 days. Okay. Got it.
And they can also say no
They can also say no.
and still get the 30 days
What?
and still get the continuance.
Well, at the initial evidentiary hearing, any party can ask and any party gets it. And that happens, and you can say, will you extend the 120-day clock? And they can say no, and you still have to grant it. That's at the first initial hearing. The second one would only be if new stuff comes in.
Okay, so the second hearing, if they want to bring new information, they say, well, we would like an opportunity to extend it 30 days to bring in new information. You say, okay, will you extend the 120 days? And they say no. Then what?
You don't give them that time.
Okay, all right. Got it.
Mike, do you have your hand up?
Oh, no. Wondering.
Okay.
I do have a question. It sounded like to me, you said, or you implied that questions about housing pretty much have to be approved.
I would be lying to you if I didn't say that that's the way the tide is moving. The laws have been framed so that housing gets approved.
With condition, it can be approved with conditions.
Has it ever been tested, ever in the courts, that when the legislature said all housing is needed housing, has it ever been tested yet whether a second home is needed housing?
The definition of needed housing in 197.307 is all housing. It doesn't say first home, second home. It says all housing. Are you saying that second home housing is not housing?
It's not.
Okay, so, but it's never been, there's no case yet that's,
On
Okay.
that question.
because that's a matter of the intent of the legislature when they made that rule. And I just don't believe that that's what they meant. I mean, that's just,
I think that they meant all housing because they believe that second housing will eventually be part of available housing.
Or it
Second
could.
Could be, correct, but that's a more proper way to say it. Could be made available for.
so you're telling me like a 10,000 square foot house on the ocean front could be available. I just want, I mean, it's just never been, I guess, you know, I'm just waiting for the case to come along where they're going to actually test that idea.
Well, the argument could also be made, the 10,000 square foot house could 20, 30, 40 years from now be the primary home for someone and not necessarily a second home for somebody. It might be constructed today as a second home or fourth or fifth or sixth home or whatever, but 20 years from now, housing market crashes or whatever, or even if it doesn't and somebody who's very wealthy comes into town and that they use that as their primary home, it's now housing.
Yeah,
not a
that's
second
true.
house.
I mean, it's never,
I think that's why the state, in my opinion, would look at all housing as housing, because even if it is constructed as something that
this seems so.
isn't necessarily great for our housing situation here, technically could be housing.
Could be. There's no way to prove that something will always be a second home. That's the problem. There is no way to prove it.
But it's hard to prove a second home too.
Yeah, even now, right, it is. I know. I'm just.
I'm gonna give you an opportunity to. You wanna say anything? You wanna add anything? Tell me.
These are all legitimate questions that I think every community is dealing with, you know, I mean, you just mentioned all the communities you represent. And so, you know, I mean, land use is a challenge, there's no doubt about it. You know, for those who are professionals that do it, it's challenging. And for volunteers like yourselves to understand everything that was just placed before you, it's hard enough to present the information. And so it's a challenging thing that we're going to all have to work together to try to get the decisions and community and things that we're all looking to do. So from that perspective, I appreciate the input and the opportunity to be here, and I look forward to working with you to hopefully make these things happen.
Thank you. All right.
I had one just clarification for me anyway. So I understand if there's a building permit brought forward, then the desire is to do everything possible to make it possible to build the house. But what other issues that come forward? Like if I have a large lot and I want to partition it down into, the implication is it will hold more houses. Am I also kind of under the same onus to make that work? Or does that get viewed differently? Or zoning change?
It's the zoning that would dictate what you're allowed. Right?
Right.
Whether or not the partition is gonna be for housing or not is gonna be dictated by the zoning, right? If it's a partition in an industrial zone, it's not gonna be housing. Right?
But if it's a
Commercial.
zoning change,
What?
but what if it's a zoning change request?
Like a zone change from different residential zone to another residential zone or a
Correct.
commercial?
No, residential to residential. Are we out, is that obligated to be approved too, since it's housing?
So I think the answer is no. But it's not been decided yet.
Okay.
It hasn't been decided yet. So my Oregon City case that I lost 3 days ago, it's a little sore subject, I know. I was arguing that the first phase of a plan unit development, so plan unit developments are usually 2 phases. There's the general development plan, or whatever you call the master plan part, where you show conceptually what you're gonna build, and then you get approval for that and you come back for your detailed development plan. And that's like sort of more a check the box, clear and objective determination. And what I was arguing was that the general development plan, the first step, didn't approve housing because you couldn't go turn a shovel of dirt, right? You can't go build anything with a general development plan. Lewis said it was housing, so.
Wow.
What about changing, for instance, a commercial zone to a housing zone? Is that,
I think the answer is no.
or
But I think the answer is no. because you can't, this is not the development of housing. This is land use planning that will allow housing some other time. That's the argument I would make, but it hasn't been tested. And again, the tide is toward clear and objective, and the tide is toward housing.
But if you are clear and objective about where you're going to allow housing and where, you know, if you're really clear and objective, that helps. In other words, if you say, we don't want, this is, you know, we have some beautiful forest and we don't want someone, you know, chopping it all down and building housing. If we have a clear and objective standard for that particular, like there would be no building in a forest. I'm just making a silly example.
Yeah.
But, you know, that's what you say in your zoning code. No building in a forest.
Correct.
That's clear and objective.
Absolutely clear and objective.
Okay,
I mean, if we're clear on what the forest is.
okay.
You know, always count a lawyer to, you know, find the ambiguity, right? All right, I really appreciate your time. It's been an absolute pleasure to be here before you. I hope to be here again soon. Well, maybe you probably hope not, but thank you.
Thank you.
And me and Bill, and we're always here as a resource for you. So please keep that in mind. Okay?
Great.
Thank you very much.
And thank you for arriving in our city, and we look forward to working with you.
For having me, I appreciate that.
Yep. Okay.